şimdi açılış konuşmalarını yapmak üzere proje yürütücüsü olan Avrupa Konseyi'nin İnsan Hakları ve Hukukun Üstünlüğü Genel Müdürü Sayın Giakoumopoulosu sahneye davet ediyorum.
Mr. President of the Constitutional Court, Presidents, Honorable Judges, ladies and gentlemen, and dear friends, it is a real pleasure to see you all gathered here today. Some of you have traveled from quite afar, and we thank you for your interest and participation. I would like first to convey my special thanks to the Constitutional Court of Turkey and my congratulations also. Today, we do not only celebrate the anniversary of the individual application system. As you have just seen, we also reached a milestone in a fruitful and productive partnership. We have completed a 3-year-long cooperation project, a very rich cooperation project, and I wish also to thank the European Union for their support for these activities. Ladies and gentlemen, the individual application has helped protecting the rights of several thousands of people since its creation. Today, as we mark the 7th anniversary of the individual application system in Turkey, we look back at numerous accomplishments and we rejoice about the long way that the Constitutional Court has gone already. And at the Council of Europe, we are very proud to have contributed to this success. I have just seen the statistics, and they are rather telling. As of today, the Constitutional Court of Turkey has dealt with 200,000 applications. Most of the bulk of these cases was actually submitted this year and the year before. And this is a clear indication of the court's reputation, of the court's good reputation and success. It reflects the hopes that Turkish citizens are placing on this institution. And rightly so, because indeed there is no important function, no noble purpose like delivering justice without a great deal of responsibility. For the Constitutional Court, the bar is set very high. And it takes courage, it takes determination, and perhaps also sometimes some audacity to be a court of last resort. And we expect no less from the Constitutional Court, which has already proven its resilience in the most difficult times. Yet, no man is an island, and this court cannot do it alone. The individual application may be a special remedy. It remains nonetheless embedded in a system, so much that it sometimes becomes symptomatic of society's illness. In a sense, looking at the individual application and the way the individual application works, the complaints that are made, is like feeling the pulse of a society. And weaknesses in the justice system inevitably will also be felt by the Constitutional Court. And this is how it should be. Ladies and gentlemen, there are 2 particular points that I would like to call your attention to today. First, the issue of the execution of the judgments of the Constitutional Court, and second, the scope of the conclusions, of the decisions that should be drawn from the judgments of the Constitutional Court. As we say in our Strasbourg jargon, the erga omnes effect, which I believe is not a very accurate legal term, but this is how we call it. As any constitutional court operating in a democracy, your institution deals with cases that are very delicate in nature. For instance, the Constitutional Court needs to ensure an adequate distribution of powers in practice, appropriate and efficient checks and balances. It needs to ensure that the executive does not overstep its powers, interfering with the judiciary or with the legislator. It needs to ensure that the legislator respects the Constitution and international law binding the state and interpret the Constitution and the law in a way that does not create unnecessary conflicts and the responsibility of the state concerned. It also needs to ensure that constitutional rights, human rights, as enshrined in the Constitution and in the law, and international law applicable, be respected by all, including by the judiciary. And this is particularly delicate because it regards the proportionality of the limitations which are imposed by judgments of regular courts to fundamental rights and freedoms such as freedom of expression, freedom of information, freedom of religion or belief, respect for everyone's private life and family life and others. It needs to ensure that people are not prosecuted, are not arrested or convicted because of their views and opinions, even when these opinions are shocking or disturbing for the society, even when they are contrary to or hurt the views of the majority. Inevitably, therefore, the judgments of the Constitutional Court may not please everyone. They point at issues that are sensitive and sometimes downright controversial when it comes to their enforcement. But we all know that constitutional logic must prevail. The Constitutional Court exemplifies a certain order, the constitutional domain, which is different from the rest of the judiciary. But one must understand the system's logic. The Constitutional Court is a court of last resort, and for this mechanism to function properly in an efficient way, Constitutional Court's judgments should apply by other courts. Instances where the Constitutional Court judgments are challenged or left unexecuted are weakening the legal order. In fact, they are detrimental to any judge because ultimately these events are sapping, undermining the judicial authority and the legitimacy. The European Court of Human Rights rightly observed that an effective judicial system is necessarily a harmonious one. Harmony is at the heart of the efficiency. Strengthening existing tools to ensure the execution of the Constitutional Court judgments will always be useful. One should perhaps consider developing a comprehensive mechanism for this purpose. Actually, in many countries, the constitutional courts are normally vested with the power of overruling directly judgments or decisions that cause violations, so that their effective implementation, execution, is not necessarily a very difficult issue. However, in Turkey, the Constitutional Court does not have this prerogative. So a monitoring mechanism at the level of or within the Constitutional Court to make sure that appropriate follow-up is given to the judgments, preserving the indispensable coherence of the constitutional order may be advisable. The second issue that I would like to refer to is, as I said before, the erga omnes effect of the Constitutional Court rulings. There are some features of the individual application system which have been read in the sense of confining the judgments of the Constitutional Court to the very limited circumstances of one specific case, restraining the scope of the judgment of the Constitutional Court. If this held true, the individual application system would have a very limited effect. The Constitutional Court judges would be like a Sisyphus, working all the time, attending each file without fulfilling the multiplier role that they should have. In order to render justice, it is sometimes necessary to consider the essence of case encountered, draw general conclusions, and in some occasions when national legislation may be at the source of violation, this might imply also working upstream with the legislator or with the executive branches. I recall that the issue of maiden names is in the center of this point. The European Court of Human Rights and the Constitutional Court of Turkey both have ruled that married women should be able to retain their maiden name if they so wish, but for the time necessary changes have not yet been effected by the law. Ladies and gentlemen, within the judiciary, our projects show that much can be achieved through dialogue. And in the past 3 years, we created opportunities for discussion at multiple levels, as you have seen, through case law fora involving the Court of Cassation and the Council of State, through roundtables with the newly established courts of appeals, and eventually through activities that have raised awareness of first instance judges and prosecutors to human rights standards and existing case law. We have witnessed over these years firsthand how this dialogue contributed to a mutual understanding in various fields. The feedback that we have received, as you have noticed, is a need to create more of such opportunities at every level. And I'm very pleased that we can already foresee the continuation of our cooperation of this project in the coming years. I wish also to use this opportunity to thank everybody here who has worked hard to make this support to the radial application to the Constitutional Court project, as we call it, the SIAC project, a success. In particular, I would like to thank the national trainers who, together with our international experts, have delivered training on human rights and the individual application system, as you have seen, to more than 6,000 judges, prosecutors, lawyers, practicing lawyers across the whole Turkey. Ladies and gentlemen, we have a dense program before us with many speakers from various backgrounds. This should be a chance to look at the individual application system from different perspectives, and I hope that you will find this interesting and beneficial. Let's not lose sight of the aims that we are working for as judges, as lawyers, as members of international organizations, international community, which is ultimately respect for individual human rights, fundamental rights, because it is precisely this strong belief in human rights that makes us European, that allows us to have a meaningful dialogue on the basis of common values, that ensures stability, peace and prosperity for everyone in our 47 member states. I wish you great success, and I thank you very much for your attention.
Sayın Giacomopoulos'a konuşmaları için teşekkür ederim.